Hi, my name is Jim Peake. I am a technical lead on civil case management, and today I'm going to take you through the basics of the means assessment process, or the civil means assessment process. I'm going to take you through some stuff about income, deductions, and capital, which are the three main elements of the assessment. I'm also going to talk a little bit about the upper and lower limits to receive legal aid, and I'm also going to give you what I hope are some useful hints and tips for um, for navigating the civil means process with as little difficulty and pain as possible. Um, yeah, we'll cover the basic means assessment process and some information about eligibility limits that clients must satisfy in order to qualify for legal aid. We'll start off with some eligibility information. So when a client applies for legal aid, their gross and disposable income and capital is assessed. The first test a client must satisfy is in relation to gross income, and their total income must be under 2,657 per month to qualify for legal aid. So that's around £32,000 per annum. If the client satisfies the gross income test, their disposable income is then assessed. And this test involves their income being calculated with deductions being made for various outgoings, which we'll come on to speak about. After their income has been calculated and deductions have been made, their disposable income needs to be less than £733 per month for them to qualify for legal aid. In terms of capital, when a client's capital is assessed, they must have less than £8,000 in order to qualify for legal aid. Important note here, though, is that if a client is applying for legal aid in order to seek protection from domestic abuse, the upper limits do not apply. So if they apply for legal aid for a non-molestation order, an occupation order, or a forced marriage protection order, the upper limits um, for legal aid are waived. Note though that they could still have contributions to pay towards the costs in their case. Just going to speak briefly about the passporting process for legal aid. So if the client receives one of the following five state benefits, they are passported through the income test. So if they get universal credit, income-based job seekers allowance, income-related employment and support allowance, income support, or the guaranteed state pension credit, they are passported on income to receive legal aid. Um, that will make the process, obviously, our process towards getting legal aid a lot easier if they're getting one of those benefits. Their capital still needs to be assessed if they're getting any of those benefits. Uh, so there is still that test to undertake. In all the means assessments carried out by the legal aid agency, a client's financial means will be aggregated with their partner's financial means unless they are the opponent in the case or there is a contrary interest. So we would aggregate usually with a partner unless they're the opponent. Contrary interest, an example would be where a couple have both been um, included in proceedings where there has been a deliberate injury to a child, and they're both potential perpetrators of those acts. So it's possible that they could effectively point their fingers at each other. So therefore, they need separate legal representation in those cases because they have a potential conflict of interest. So starting to talk now about income. Most income that a client or their partner receive will be included in any assessment of their financial means. So that includes all the income you would expect us to assess. So wages, stroke salary, if they're self-employed, the income they get from that self-employment. Most state benefits are included in the assessment. Any student finance they get will be included, other than the payment that goes directly for their tuition fees, which we wouldn't assess. Um, any maintenance payments they receive, we will include in the assessment, and any financial support from third parties that they receive on a regular basis would also be included in our income assessments. Um, any rental income they receive, if they rent a property or properties that they have, will be included in the assessment as well. Some state benefits are disregarded from the assessment process, and the most notable ones are personal independence payments and carers allowance. Those are the two we see most frequently that clients receive, and the caseworkers are trained not to include those in the assessment. There are many others on the disregarded list as well, and very shortly there will be some further benefits added to that list as part of the means test review. So the next phase is due to come into force on the 20th of November, and disregarded benefits to be added there once the statutory instrument has been implemented include the payments that victims of modern slavery receive. They will be added to the disregard list as of the 20th of November. Coming on now to talk about the deductions that can be taken off the income. Again, it's largely the items that you would expect. So if a client's in employment, we can make allowances for their income tax, their national insurance number, sorry, their national insurance, and also a fixed allowance for employment expenses can be made as well, which is currently £45 per month. There are also fixed allowances for dependent children and adults. If the client pays rent or mortgage, then an allowance can be made for those payments. And also, if they make any maintenance payments or childcare payments, allowances can be made. Those last three categories, so the rental, mortgage, maintenance payments, and childcare payments, we would expect those to be evidenced. So the client may need to highlight them on bank statements or produce some other evidence that they've made those payments before we can make an allowance in the assessment process for them. Allowances for a client's food, clothes, gas, and electricity are inbuilt within the assessment process, and the combined allowance for these items is £315 per month, and that's the lower income limit. So any client assessed to have a disposable income of less than £315 per month will not have to pay a contribution towards their legal aid from their income. So effectively, they won't pay anything from their income there. Some key items that you would expect allowances to be made for aren't allowed in the process. So there's no allowance for council tax. The means test review that's been undertaken at the moment proposes to expand the number of allowances available to clients to potentially include items such as council tax, student loan repayments, and the repayment of certain priority debts. Those haven't been defined as yet. So there will be some scope in the future for more allowances to be made against income than can currently be taken account of. Moving on to capital, after a client's income and deductions have been assessed, their capital position needs to be considered. In calculating a client's capital, the following is assessed. So the balances of their bank accounts is taken into account, although on current accounts, it will only usually be the residual balance of those accounts that's considered. By residual balance, we mean the lowest balance in effect in any given month. So, for example, if you were paid on the first of the month, you would want your balance of your current account to be taken on the 31st of the month when all your outgoings and all your bills for a month have been paid. So that's considered to be the fairest way to assess the balance of a current account. Any equity in a client's property or properties will usually be taken into consideration in the assessment, subject to various disregards. Any items of value a client owns, which are worth more than £500, we will include those in the assessment of their financial means. Value of any cars they own are usually considered, although subject to certain limits there. So usually, providing the car's worth less than £15,000, it doesn't usually impact the assessment of their financial means. And then some more niche items of capital that you see occasionally are also included in the assessment. So if a client had a trust fund, we would be looking to assess the value of that. And if they were due an inheritance, we would also be looking at including that in the assessment as well. So there's a couple of items there to consider as well. A client stroke their partner, if included in the assessment, qualify for legal aid if they are assessed to have less than £8,000 capital. If they have between £3,000 and £8,000 in capital, they will pay a contribution on a sliding scale. So, for example, if they have £7,000, they will be asked to pay a contribution of £4,000 towards their legal aid. But if they only have £4,000 capital, they would only be expected to pay £1,000 towards their legal aid. And a note there at the bottom, if they are applying for legal aid to seek protection from domestic abuse, the upper limit does not apply. For example, they could be assessed to have £10,000 of capital and still qualify for legal aid, albeit they would be expected to pay a contribution of £7,000 in that instance. So just moving on to some useful hints and tips for providers here. When assessing if your client is in receipt of an income passporting benefit, the clients who have an open universal credit claim but do not currently receive payments are not passported for legal aid assessment purposes. So do check that your client is actually getting a universal credit payment. The monthly eligibility notifications that clients are sent for universal credit usually spell out whether they're getting a payment or not. Usually that's right at the top as well, so you can see clearly whether they are receiving a universal credit payment. If they're not, then you need to do a full assessment of their financial means, basically, before working out whether they qualify for legal aid or not. Be aware that there are two forms of job seekers allowance and employment and support allowance, and the contribution-based versions are not passported through the assessment process. So do keep an eye out for that as well. And I just want to do a little bit of promotion here. We've recently introduced a new email address to help providers. It's called contactmeansexpert@justice.gov.uk. Being fully rolled out now to providers, so everyone should have access to that address. And it's a rotated job, so there's a caseworker on the end of that address on a day-to-day basis, and you should expect to get a response to any email you send to that address within 24 hours. It's from the legal aid agency's perspective, it's very much aimed at trying to help providers to get things right first time. So the legal aid process is as painless as possible for everyone involved. Just some additional contact details for us here as well. So I've already mentioned the contact means expert address. If you've got any general queries, they can be sent to the contact civil address, which is there on the slide. For inquiries in relation to specific cases, you can obviously send a case inquiry or a means inquiry via CCMS, and there's been a recent update to the system which allows you to attach documents to those notifications as well, which should hopefully make things easier both for yourselves and for the caseworkers. The customer service number is 0300 200 2020. So if you want to speak to an individual, then you can ring that number and get some verbal advice. And there is a link there to the current means assessment guidance as well. So just some other little bits and bobs here as well. There are some CCMS quick guides available on the link there. If you're new to the system and are still finding your way with it. There is there's periodically some online training on CCMS available, which you can sign up for if you see that advertised. There's a web chat available for any IT systems that any IT system issues you're experiencing, you can use that. And there are periodic webinar recordings like this one where we use the umbrella Help Us Say Yes. So those are the webinars where we focus on areas where there have been issues or lots of inquiries, and we try and provide a bit more information to help providers. Popular sessions are posted on the Ministry of Justice's training website and also the Legal Aid Agency's YouTube channel. So remember to like and subscribe to that if you use it regularly. Communication channels, there is a fortnightly alert with links to relevant pages. So you can sign up for that on the link there. Social media, we're on X, so you can find us there at Legal Aid Agency. And there's also a customer services Twitter account that you can sign up for. There's periodic blogs as well on social media. And in terms of knowing the status of the systems that we use on the Legal Aid Agency's portal, we post the status of our online systems on the portal's homepage. So if any of the systems have got are encountering issues or they're down for any reason, you should be able to get that information from on there. So thank you for listening to me, and that is the end of this presentation. Thank you.